let's go to an email.
All right, that's a great idea. We do have some great emails we received this week. Lisa from Conway Springs emailed me. She said in 1975, I was injured at work. My back required surgery. I had a 3-level fusion. I returned to work 3 years later, and then in 2012, my back popped while I was lifting at work, and now all of the pain has returned. They're denying my claim. Can I sue? Well, that's a great question, Lisa. If you can prove that the employer or co-employee was negligent in causing your injury, causing this latest injury in 2012, and you lose your workers' compensation claim, then you could perhaps sue them, your employer, I should say, for the damages that you sustained in the accident. Now, if the accident is your fault, then there's not much you can do about that in a lawsuit because comparative fault law in the state of Kansas says that if an accident involves 50% or more of fault on your part, then you cannot recover damages. You have to have 49% or less fault in order to recover damages against someone else. So in this situation, typically this would be a work comp claim. I think I see why your employer is denying the claim, because they are arguing that there's a pre-existing condition, and perhaps they're also arguing that the prevailing factor is this prior 3-level surgery, prior injury, and so forth, and that this latest episode is merely an aggravation and not the prevailing factor for the need for additional damages. If that's true, and again, you can prove that someone other than yourself was more negligent than you in causing your injuries, you can sue for your damages that you've sustained in this work-related accident, including pain and suffering that you can't get in work comp, including lost wages that you don't entirely get recovery for in work comp, including all of your medical bills and any other damages that you don't typically get in work comp. You can sue the employer in this particular type of scenario and make a recovery to the extent that you can prove the employer or any of their agents was responsible or negligent in causing your injuries. This is a tricky area of the law, though, and you want to proceed carefully, because you could spend a lot of time and money on one of these cases, and then the courts could say, well, wait a minute, you should have pursued a work comp claim because the exclusive remedy in work comp covers your particular accident. And so I'm suggesting to a lot of the folks that I talk to about this particular scenario is that we first get an administrative denial of the workers' compensation claim by the workers' compensation system before, if they want to sue the employer for a negligence cause of action, they're going to need to get an administrative denial of their work comp claim. In other words, litigate a little bit in the work comp circles, and then file the lawsuit. All right. Thank you, Lisa. You need to get with a lawyer right away on that one.